I'm Drew Stevenson, and this is a lecture for my administrative law class about Justice Black's dissenting opinion in Goldberg v. Kelly. We're going to be talking about public assistance programs and procedural protections for the recipients. And first, let me explain, why are we talking about this dissenting opinion? Do dissenting opinions matter? In a lot of cases, maybe they don't, right? Because the majority opinion is what actually becomes the law. In this case, though, Justice Black lays out some talking points or some points about welfare programs and costs and benefits that really became the framework for a lot of our public policy debates about government assistance programs, all types of government assistance programs, not only for the poor, but for students and veterans and for the disabled and so on. And so these arguments haven't gone away. And so his points and the majority's kind of pushback against them are really worth looking at to understand the types of arguments that continue to come up today in welfare government cases related to government programs and assistance. So let's take a look at our slides. So one of his first points, and I'm not necessarily going in the order of the opinion, but one of his first points is he emphasizes the burgeoning welfare roles of the era. Remember, this case worked its way up to the Supreme Court in the late 1960s. The decision comes out in 1970. And this was a time when, as the majority calls it, there was a social malaise, and we needed a social safety net for the millions of Americans who were falling through the cracks and falling into poverty, as the majority says, through no fault of their own. And so President Johnson at the time had declared war on poverty, and there was a big expansion of government programs and benefits kind of that coincided with the civil rights era of the 1960s. Well, by the time we get to 1969, 1970, Justice Black is sounding the alarm that this is spinning out of control. They're growing too fast and they're too expensive. And he says there's a cost to government programs besides just the money that you're dispersing to people. There's also an overhead cost of running a program. And this is a good point that you should always keep in mind when you are thinking about administrative law, that the bureaucracy itself, those people have to be paid, and we need buildings and facilities and computers and phone lines and parking lots and things like that. And so he says, if we're going to have pre-termination hearings, in order to do the hearings faster, we're going to have more hearings. And if we have more hearings, that means more hearing officers, more rooms to hold hearings in or facilities, and more clerical staff and so forth. So the costs, the overhead costs for the agency just got higher, he said, because just by the majority shifting the timing of the hearing to pre-termination, because we're going to have to speed up the scheduling of the hearings in order to do that. He also makes a point that's partly true, but not completely true, that this is coming out of the agency's benefit. And he is afraid that it means that there's less money to actually distribute to the poor, right? So if you think about a philanthropy or a charitable humanitarian organization, if they spend half of their budget on overhead costs, then half of your donations to them, only half of every dollar is actually going to help people. That's the argument. And he's making a similar argument about overhead costs for welfare agencies and what we're doing when we give more procedural protections. Students, please keep in mind that procedural protections always come at a cost, right? They're not free. So the more hearings we give, the more government employees we have to do those hearings, the more facilities we have to have. And maybe that's worth it, but it's worth asking the question, what is the cost of giving one more increment of procedural protection? He also makes this point that some of the terminated recipients are people who were never really eligible before. This is actually one of his very first points in his dissent. And so they were wrongfully receiving benefits. And now somehow these ineligible people, according to the majority, have a right to ongoing payments. And in other words, he said, if they're later found never to have been eligible, then how could they possibly have a right to a hearing or a property interest? How could you have a property? He basically takes the majority's argument about property interests and entitlements and turns it on its head and says, okay, I understand that a property interest entitles you to procedural safeguards. I understand that if you are eligible for a program, then you have a property interest in that program or license or permit or loan or whatever it is. But if you are never eligible, how could you have a property interest that triggers due process? So he's saying the ineligible people don't deserve a hearing before we cut them off. He also, this is very important, characterizes welfare as charity. And the majority in Goldberg v. Kelly rejects this when they hold that these programs are an entitlement. And this is a point that continues to come up again and again, even today, when we talk about government assistance programs or poverty reduction programs and so forth, using the administrative state to do it, is this charity? And the words matter because they have a lot of semantic connotations. From Justice Black's standpoint, charity is something that you don't have to do. You're not obligated to do it. So it's an act of generosity, and the person who's receiving it should feel grateful, not entitled, right? And this resonates with a lot of people intuitively, at least when we talk about charity, right? He says it's one thing, if you're paying your bills, right? You pay your electric bill. You're not being generous by paying your bill. If you eat at a restaurant, you pay your bill, pay for your food. You're not being generous. You owe that. But if you give money to a panhandler on the street, you didn't have to do that. Lots of people don't. They just walk right by. And so the fact that you did is sort of above and beyond. You're being generous or virtuous. And therefore, the person doesn't have any rights that they can assert, like you have to give me something. The majority says that's not what's going on here at all. The fact is that the legislature has a right to create programs. And if you want some examples, they don't give these in the case, but if you think about veterans benefits or Social Security retirement benefits, a lot of people don't think of those as charity. They feel like they earned them. But remember, it's not really exactly like a contract, right? So is the government paying its bills when it pays veterans benefits and Social Security benefits? And the majority says it's not some big act of generosity of the government doing that. We decided to take care of senior citizens. We're going to tax them while they work, and then we send them a stipend when they retire. That's Social Security, or we take care of our veterans, on and on. And they say once the legislature says if you meet these criteria, then you are eligible for this program. We could do the same thing, for example, with student loans, right? Are you eligible for student loans? Or if we have a student loan forgiveness program, are you eligible for the student loan forgiveness program? And the majority says it's not charity when we give you student loans, you meet the criteria, right? So it's a legal right that you have now that the duly elected legislature has determined. And so for Justice Black to characterize it as charity basically is another way of saying these people have no right to any type of process. Here's his most complicated, and also I think his weakest point. He insists that this is like a periodic payment contract, which seems to contradict his point that this is charity and something we don't owe. So if you think about a subscription where one side is paying regularly, and so let's say that you subscribe to one of those meal subscription programs where they send you the ingredients to put together a nice meal regularly, and then you decide that you don't want it anymore, so you cancel your subscription and stop paying. Well, we're not going to allow them to take you to court and make you keep paying even when they're not sending you the stuff that you were subscribed to, or once the subscription is canceled, right? And so he says that there's no such thing in common law. I think he's wrong about this. We have something in common law that we call preliminary injunctions. We have these very commonplace remedies in child support disputes, certain contract claims, wrongful termination lawsuits, and so forth, where you can go before trial, and if you show the likelihood of prevailing on the merits and undue hardship in the meantime and things, so you can prove some factors, you can continue the payments during the pendency of the litigation. Also, he brings up a point that if you're paying people and then they eventually do lose at their hearing, we're never getting those benefits back, right? They're already spent and these people are judgment proof and so forth. So he says they're judgment proof, and the majority is living in this fantasy world that the ineligible people, we're just going to make them pay what they owe. He says you're never getting that money. But if you make a mistake and and you made a mistake signing someone up, and then we have to keep paying them, we're never getting that money back, he says. Now, this is one of his better points. He makes a prescient economic argument that if you make it harder to kick people off of a government program like welfare, it will inevitably mean it becomes harder to get on the rolls in the first place. And this is probably true. So in a lot of our programs, we have over the years, as we have added procedural protections for people being terminated, we've ended up front loading the screening process. And so we have more and more elaborate application processes and rigorous screening. So it's harder to get signed up in the first place. And he said, and the problem with that is that we're going to have some people that get the screening is a little too tough, and we screen out some of the people that the Congress actually wanted to help and who were actually eligible, but because we're making the other kind of mistake, we're rejecting people now because it's so hard to get signed up. And this is an interesting argument. If you think there's an argument that conservative economists make with that's very similar with employment protections. They say in jurisdictions that have more worker protections, where it's harder to fire people, then it's also employers are more hesitant to hire someone because it's harder to get rid of them once you hire them. So the argument goes that that we end up with higher unemployment when you make it harder to fire people because employers are afraid to hire or are going to make you go through this very protracted interview and background check process before they hire you, and they're more likely to keep just shifting a work around internally to the dumping more work on the employees they have instead of hiring more people because they're afraid if they hire someone who's not a good worker, they'll never be able to get rid of them. So the argument from some conservative economists is that when you increase worker protections, you increase the unemployment rate because employers don't want to hire people. They're slower to do it, they're more hesitant, and they just end up hiring fewer workers, so there's fewer jobs. And Black is making this it's the very same argument about government programs, that the more procedural protections you add on at the back end when you're cutting people off, that will naturally result in more screening mechanisms at the front end, so that it's harder to get signed up, and that can end up hurting the people we wanted to help. He was also right that Goldberg was going to be the start of a trend, and that there would be a lot of other types of benefit programs where we would continue paying until judicial review is complete. On the other hand, here's some things I think he got wrong. He said that that this was a slippery slope, and next thing you know, everybody's going to also be entitled to a free lawyer at the government's expense at their welfare hearing, sort of like the court had done a few years before this in Gideon versus Wainwright for criminal trials. So criminal defendants have, if they can't afford a lawyer, have a right to a lawyer at the state's expense. And he was sure if you're creating a right to a hearing, then we're going to have a right to a lawyer at the state's expense. And that never really happened, right? So we do have government funded legal aid, but you're not guaranteed to do that. The legal aid clinic gets a grant and they're still limited in how many people they can help, how much the staff they have. You're not entitled to a lawyer. You can, if you can afford a lawyer, you will always have a right to bring your lawyer to your hearing for your government program or benefit or whatever it is. But you can't go and demand a free lawyer from the government. So he was sure that was going to happen. Slippery slope argument that didn't really materialize. Also, although he's correct that there are some government programs where we have made the initial application process probably too difficult and cumbersome, like really, really ridiculous. On the other hand, especially in emergency situations, like with a stimulus during an economic crisis, or with FEMA debit cards and housing vouchers after a natural disaster, we don't screen very carefully at all. And so we end up with lots and lots of stories of fraud and people signing up for things that they weren't entitled to and scamming the system. And so we do this with some, but we do it selectively. And there's other programs where we don't do this at all. So he seemed to think in absolute terms, and it's ended up being a lot more nuanced than that. Third, his last point seriously undermines that first or earlier point. Remember that he said that there were a lot of people who were never eligible to get benefits in the first place. So why should we keep paying them when they get a hearing that they're also not really entitled to, right? If they weren't eligible for the benefits. But if he's correct that we're going to end up having really rigorous screening to make sure we don't make mistakes on the front end because it's hard to get people cut off, then that other problem that he's worried about kind of starts to go away or goes way down. There's going to be fewer and fewer people that are wrongfully signed up who were never eligible in the first place. Why? Because we're screening so carefully at the front end. So some of his arguments, they're very insightful, but some of them actually cancel each other out. He also makes a good point and an interesting point for future litigators to keep in mind, that if you can pitch your case as the big, gigantic government's pocketbook versus the poor individual, then it's always going to seem like, why can't we just help the individual, right? So we want to give this person $100 a month or $1,000 a month even, and that's a drop in the bucket for the government. And even for one government agency, that's like nothing, right? To just help this one more person, but for the person they help, it's everything. It could be a matter of life and death. And so, and he makes it, that is a good point, at least as far as like the psychology of pitching a case. And I'm not sure it has necessarily always played out in our political process, but it does have an effect in court. A clever lawyer, if you can pitch your case as sort of in Pareto terms, we might say in economics, that look, this doesn't really cost the government or this big corporation very much. They're not even going to miss the money. And for my client, it makes all the difference in the world. So why can't we take just a little bit that they're not going to miss and change the life of this person? And that's always going to resonate with some judges or jurors. He was also right that there would eventually come a public backlash. And in the 1990s, the public had become very upset, very frustrated with the welfare system. And we had a major overhaul while Newt Gingrich was the Speaker of the House, and the Republicans controlled Congress for a brief period in the late 1990s, and severely contracted our government welfare programs and added a lot of conditions and things like that. We have a statute that says that the very program in Goldberg v. Kelly, it renames it temporary family assistance and says it is not an entitlement, and things like that. So he was right. It took about 20 or 25 years that eventually the public was going to get fed up, and the parties, the political parties, were going to start talking about like multiple generations, a cycle of poverty. These people were born and raised on welfare, and now their children are growing up on welfare. They have no motivation to go get jobs and help themselves. That's what people say, and he saw that coming. That people would make those arguments. And even today, you'll hear sort of a libertarian type argument that essentially amounts to you're hurting people when you help them. If you help people, then you're making them lazy and complacent, and they won't pull themselves up by their bootstraps and so forth. So if you actually help the poor, but keep in mind, that's an argument against charity too, not just government programs. Um, but he was correct that there would be a public backlash, and that did in fact happen and continues to this day. Okay, that concludes our brief video about Justice Black's dissent in Goldberg v. Kelly, which is important because it sort of lays out some arguments that became the talking points in the years that followed about various types of government programs.